Mr. Kneedler.
Mr. Chief Justice, and may it please the court. In Robinson, this court held that the government cannot criminalize status, and respondent has conceded here today that the city cannot criminalize the status of being homeless. Our narrow submission in this case is that government cannot circumvent the principle of Robinson by making it unlawful for a person to reside in the jurisdiction if he has that status. That is what the ordinances here do. As applied to someone who has nowhere else to sleep, which is an essential human function, the ordinances are the equivalent of making it a crime to be homeless while living in Grants Pass. Although we think the Ninth Circuit was right to recognize that the core principle of Robinson is implicated in this case, the court was wrong to award broad injunctive relief in the circumstances and manner in which it did. The Robinson principle requires an individualized determination, and the Ninth Circuit's failure to require such a determination and its issuance of much broader injunctive relief has led to the problems at issue that the petitioner and its amici have raised, not the core principle of Robinson. And therefore, we urge the court to adhere to the core principle of Robinson, but to emphasize that cities have flexibility to implement these, and in particular, time, place, and manner restrictions on where someone can sleep are entirely valid if they are reasonable. And indeed, the state law that Justice Jackson referred to establishes a state policy that time, manner, and place restrictions are the way to go if they are reasonable. I welcome the court's questions.
Mr. Kneedler, wouldn't you have a better argument if Robinson involved someone being arrested for using drugs, but then the court said that you were in effect arresting him for the status of a drug user because he had no choice but to use drugs because he's an addict?
No, our position is not that the conduct, as in Robinson, the drug addict can't stop from using drugs. That is not our position. That's a question of personal culpability on the basis of what.
So what's the difference between that and camping out? What you're saying here, it seems as though you're saying, well, there's no other choice, so you have to camp out. Therefore, you're really arresting this person for the status of homelessness.
Yes, but not because of an involuntary compulsion sense. I think, as Justice Alito pointed out, the nexus here is actually closer than in the addiction situation, because sleeping outside is essentially the mirror image or the other side of the coin, or the definition of the status of homelessness.
Mr.